what is a preliminary hearing here in San Diego County. If you're watching this video, chances are you have an upcoming preliminary hearing, or you're going to attend a preliminary hearing for a friend or a loved one. And if that's the case, I'm sorry to hear. If you want to know what happens at a preliminary hearing, or if you're just interested in the topic, this is the video for you. Hi, my name is Dodd. I've been a criminal defense attorney here in San Diego County since 2004. My firm is DOD Law. Today in this video, I'm going to tell you what happens at a preliminary hearing. Now, a preliminary hearing comes after the arraignment and after a readiness conference. I already have a video on what is a felony arraignment. You can watch that video. I have a video on what is a felony readiness conference. I also have that video as well. In this video, we're going to talk about a preliminary hearing. What is a preliminary hearing? To make it very simple, a preliminary hearing is a mini trial without the jury. It's the defense attorney, the prosecutor, the judge, the court reporter, the deputy, and the person who's accused of a crime. You go to the courtroom, and it is the prosecution's burden of proof. And keep in mind, at a preliminary hearing, it is a very low burden of proof. It's a probable cause standard, okay? At a jury trial, it's different here in this country. At a jury trial, the prosecutor must find you guilty beyond a reasonable doubt. It's the highest standard of proof in this country. That is not the case in a preliminary hearing. At a preliminary hearing, the burden is extremely low. And what are the advantages of a preliminary hearing for the defense? Now, this is the first opportunity that your defense attorney will get to cross-examine the witnesses and see what the evidence is against you. So hypothetically speaking, let's say we're at a felony domestic violence preliminary hearing. The alleged victim is going to testify. The defense attorney gets an opportunity to cross-examine the alleged victim for the first time. And then there's a court reporter that's keeping a record of the actual preliminary hearing. Your defense attorney will get a copy of the transcript of what the alleged victim said. So if the case goes to trial and the alleged victim testifies and says something different than what she said at the preliminary hearing, you have the transcript. You can impeach her with her prior testimony because you have the transcript and because you did the preliminary hearing. So those are some of the advantages of a preliminary hearing. You get to lock in witness statements. You get to see what the evidence is against you. Now, the question that everyone always wants to know is, will I have to testify at my own preliminary hearing? And the answer to that is 99% of the time, the defense does nothing at a preliminary hearing. We do not put our client on the stand. We do not present evidence because it's such a low burden of proof. Chances are the judge is going to find that there's sufficient evidence for this case to move on and go to the next level, which would be the jury trial. And once the judge finds that there's enough evidence to go to trial, well, at that point, you already have the transcript, you have witness statements. So when you go to trial, you're ready to go. Now, if you like this video, you can go ahead and hit that like button. You can also subscribe to our channel. You can go back and watch our previous videos. Thank you for watching this video. If you have any questions, you can go ahead and give us a call. My name is Dodd. I'm the attorney with DOD Law here in San Diego County. Thank you.